Welcome to a custom-tailored deep dive, where we're basically uncovering the hidden tripwires of the legal world for you today,
Hidden tripwires is, yeah, that's exactly the right way to put it.
right? Because, when you walk across a state line, nothing physically changes.
Oh,
I mean, the grass looks exactly the same. The asphalt on the highway hasn't shifted an inch.
yeah.
But legally,
Yeah.
you've just walked through an invisible force field.
You really have. It's a complete shift in reality.
Suddenly, there's an entirely different sovereign power that can, theoretically, pull you into a courtroom, freeze your bank accounts, and hold you accountable. And the question we want to answer for you today is, how exactly does that invisible network? Like, how does a court in one geographic location actually get the power to reach out and grab you when you live somewhere entirely different?
It feels like an abstraction, almost like matter. But it is actually a highly engineered, meticulously calibrated system. We tend to think of geography as just, well, lines drawn on a map. But in the legal system, those lines represent the ultimate boundaries of state power. Every single time you cross one or send a product across one or even just send an email across one, you're interacting with that state's sovereignty.
And that mechanism of power is exactly what we're deconstructing for you. We're looking at the invisible geographic boundaries of the legal system, focusing specifically on how a court establishes the authority to force someone into a lawsuit in a specific state.
Right. The real nuts and bolts of it.
Exactly. And to do this, we're pulling from a really great stack of sources. We have excerpts from Legal Lore, the Engaging MBE Study Guide. And for those of you not living and breathing law school, the MBE is the multi-state bar examination. We also have a very precise analytical breakdown called Principles and Mechanics of Specific Personal Jurisdiction. Our primary mission here is to unpack the exact mechanics of this whole system.
And that word mechanics is really crucial here. I mean, we are talking about personal jurisdiction today, but we need to isolate a very specific flavor of it, which is specific personal jurisdiction. To understand how it operates, we really have to look at the structural limits placed on courts.
So let's set a baseline to conceptualize this, just to make it grounded. Reading through the sources, the clearest way to understand specific jurisdiction is to contrast it with its big sibling, general jurisdiction.
Yeah, that's the best starting point.
If we think of general jurisdiction, it is essentially your hometown. If you're an individual person, it's the state where you are domiciled. If you are a corporation, it's your state of incorporation, or, your principal place of business.
Or you hang your hat.
Exactly. Because you are at home in that state, you are deeply embedded in its infrastructure. And the trade-off for being at home is that you can always be called into court in that state for absolutely anything you do anywhere in the world. It is this massive all-purpose blanket authority.
Right, because the state provides you with comprehensive benefits, so you answer to them comprehensively. It is a total alignment of geography and legal accountability.
But specific jurisdiction, which is our focus for today, operates under a completely different philosophy. Specific jurisdiction is, it's like being called out while you're on a vacation because of something you deliberately did while visiting that vacation spot.
That's a great way to put it.
You aren't from there. You don't live there. But if you walk into a souvenir shop in Florida and knock over an expensive display case, the Florida courts have power over you for that specific incident.
Yep.
They cannot sue you for a contract you broke in Seattle a year earlier, but they definitely have you for the broken display case. It is strictly, entirely claim-linked.
And because you are merely visiting or perhaps, just sending a single product into that state, the law has to be incredibly careful about when it allows that state to flex its sovereign power over you.
They can't just do it on a whim.
Exactly. To control that power, the legal system relies on a very rigid three-part engine to establish specific jurisdiction. And this engine, it must be built in an exact, uncompromising sequence.
An engine that has to be assembled in order. I love that. So what are the three distinct components we're looking at?
Okay, so part one requires purposeful availment or purposeful direction by the defendant.
Okay, purposeful availment or direction.
Right. Then part two is relatedness, meaning the specific lawsuit has to arise out of or relate to that purposeful conduct from part one. And finally, part three is a fairness analysis.
And you mentioned it's an uncompromising sequence.
Oh, absolutely. You cannot skip steps. If part one fails, the engine never turns over. A judge can't simply jump to part three and declare a lawsuit fair if the first two components are missing.
Wow, okay. So let's start building, beginning with part one, the defendant's deliberate choices. Since we've established that a defendant can't just be sued anywhere for anything, the foundational question is how a defendant actually reaches into a state in the first place. The sources use this specific term, purposeful availment.
Yeah, purposeful availment. It hinges on the concept of a deliberate connection. The defendant must have actively chosen to create a relationship with the forum state. They intentionally reached across that invisible boundary we talked about.
Give me an example of what that looks like in the real world.
Sure. This happens when a company actively serves a state's market, or they set up ongoing warranty services for customers there, or maybe they run advertising campaigns targeted specifically at that state's residents.
So they are throwing a line out there.
Exactly. By doing so, they are intentionally benefiting from the forum state's laws, its economy, its protections.
Okay, let me test the limits of that deliberate action for a second. Let's imagine I own an independent single-location motorcycle dealership in State B.
Okay, still B.
I sell a high-end motorcycle to a customer who just walks into my shop. 6 months later, that customer gets a new job, backs up a moving truck, and relocates to State A, taking the motorcycle with him.
Right.
Now, while he's riding on a highway in State A, the brakes spontaneously fail, he crashes, and he sustains serious injuries. Now, my product is physically located in State A, and it caused catastrophic harm in State A. Is my dealership on the hook to defend a lawsuit in State A?
Your dealership is completely safe from a lawsuit in State A.
Really? Completely safe?
Completely. This scenario illustrates one of the most vital rules mapped out in our sources. Defendant-created contacts count toward jurisdiction, but plaintiff-created contacts absolutely do not.
But wait, even though the physical metal and rubber that I sold is exactly what caused the damage in that specific geographic location?
Yes, because the physical location of the product at the time of the injury is secondary to how it actually got there. You, the defendant, did not target State A. You didn't run ads in State A. You didn't deliberately ship the motorcycle there to expand your market.
Right, I just sold it in my own shop.
Exactly. You operated entirely within State B. The product only drifted into State A because the consumer unilaterally decided to travel. The legal system recognizes that it would be structural chaos if local businesses could be dragged into courtrooms across the country simply because their customers are highly mobile.
Oh, wow. Yeah, I guess that makes sense.
The initial contact with the state has to originate from the defendant's own deliberate strategy.
That structural protection makes a lot of sense, actually. A business requires some baseline level of geographic predictability just to function. I mean, if consumers are constantly moving the jurisdictional tripwires every time they take a road trip, you couldn't price insurance or manage risk at all.
Precisely. The system requires that predictability. Now, purposeful availment primarily deals with commerce, products, services, contracts. We also need to examine the other side of the Part 1 coin, which is purposeful direction.
Purposeful direction. How is that different?
Well, this concept applies almost exclusively to intentional harms, what the legal world calls torts. We're talking about civil wrongs like fraud, defamation, or intentional interference with someone else's business contracts.
Ah, okay. So in those situations, a defendant isn't just selling a defective toaster. They're metaphorically throwing a punch across state lines.
That is the perfect analogy. The inquiry for purposeful direction asks whether the defendant explicitly aimed their conduct at the forum state. Imagine someone publishing a highly defamatory financial newsletter.
Okay.
If they specifically target readers in State A with the explicit goal of ruining the reputation of a local business operating in State A, well, they have purposefully directed their harmful conduct into that sovereign territory.
Okay, I want to look at the ripple effects of that kind of directed action. Let's play out an economic scenario.
Sure, let's hear it.
Let's say I am domiciled in Colorado. I enter into a major service contract with a vendor who lives in Nevada. We negotiate the entire deal in Nevada. The services are supposed to be performed entirely in Nevada, and the governing law is Nevada-centric.
Very Nevada-heavy.
Very. But eventually, the vendor completely flakes and breaches the contract. Now, I'm sitting in my living room in Colorado, and I am watching my bank account drain because of this breach. I am feeling all the tangible financial pain right here in Colorado. Doesn't that localized economic pain give a Colorado court the hook they need to step in and protect me?
You've just walked directly into the ultimate effects-based trap.
Oh, I walked right into it.
You did. The sources explicitly flag this as a classic testing point for law students and practitioners alike. The answer is a definitive no. The plaintiff's residence alone is never a magic hook for jurisdiction.
But the harm is materializing in Colorado. The consequences are happening to a Colorado resident.
The consequences are there, yes, but the defendant's deliberate actions were not. The rule demands that the defendant explicitly aim their conduct at the forum. In your scenario, the vendor negotiated in Nevada and was supposed to perform in Nevada. All of their directed energy was localized there.
So the fact that I'm hurting in Colorado doesn't matter.
The fact that you happen to live in Colorado and experience the downstream financial ripple effects in your local bank account, that is considered a plaintiff-created contact. You cannot manifest personal jurisdiction out of thin air simply by living in a state and feeling the consequences of a distant action there.
Wow.
The defendant must target the sovereign state itself, not merely injure an individual who just happens to reside within its borders.
Man, we really have to isolate the defendant's agency here. The analysis puts blinders on to look strictly at what the defendant chose to do, where they pointed their resources, and where they intentionally planted their flag.
That's it exactly. And that completes the first component of the specific jurisdiction engine. We have established a deliberate contact. However, merely having a deliberate contact with a state does not instantly expose a defendant to any and all litigation there.
Okay, let's bridge to part 2 then. The lawsuit's connection to that contact. Let's assume a defendant does deliberately target a state. Say, a business owner who lives in State B decides to purchase a lucrative rental property in State A.
Okay, a solid contact.
Right. They pay property taxes in State A, they sign leases with tenants in State A, and they actively manage the building. They have unquestionably planted a flag and purposefully availed themselves of State A's market.
Definitely.
But if that same business owner gets into a random car crash with me back in State B, I can't suddenly drag them into a court in State A for the car crash just because they happen to own a rental property there,
Yes,
right?
no, you absolutely cannot. The specific lawsuit must actually connect to the specific actions the defendant took in the forum. The legal terminology for this is the arise out of or relate to requirement,
Right, it's a way to part.
often abbreviated simply as relatedness. Specific jurisdiction relies exclusively on the forum contacts that are directly affiliated with the lawsuit currently sitting in front of the judge.
Because the rental property and the car crash are operating in totally different universes. You have a solid contact with the state, but the lawsuit has zero relationship to that contact.
Exactly. Our sources refer to that as the claim-specific trap. Unless general jurisdiction applies, meaning the defendant is actually at home in the state-specific jurisdiction, will fail entirely if the contacts are unrelated to the core of the litigation.
The car crash example is pretty black and white, but the sources dive pretty deeply into the phrase arise out of or relate to, noting that courts don't always demand strict, literal, but for causation to satisfy this step. There's a massive gray area.
Oh, there's a huge gray area. The definition of relate to is where the legal architecture gets highly nuanced. The Supreme Court has clarified that relatedness is broader than a strict causal chain, but there still must be a meaningful, substantive affiliation between the defendant's activities in the state and the lawsuit itself.
And to illuminate this, the source material breaks down a critical showdown between two major Supreme Court cases, right?
Yes, the Ford pattern versus the Bristol-Myers pattern.
Reading these two cases back to back is jarring, I have to say. I mean, they feature massive corporations with nationwide reach. They both involve products causing injuries, yet the jurisdictional outcomes are diametrically opposed. Walk us through the Ford case first.
Sure. So consider the footprint of a massive automaker like Ford. They aggressively sell vehicles in State A, they blanket the local television networks with advertisements, and they continuously ship replacement parts to a network of local dealerships.
Right.
They have poured millions into cultivating a robust market for a specific model of vehicle in that state. Now, a resident of State A is driving that exact model on a local highway. The tire tread separates, the vehicle rolls over, and the resident is severely injured.
The company targeted the state, and the state's resident was injured by the product within the state's borders. That seems like a textbook fulfillment of the engine's first two parts.
It does, until you introduce the key wrinkle.
Okay, what's the wrinkle?
What if the injured driver did not buy that specific vehicle in State A? What if they purchased it used from a private seller in State B several years ago, and then later drove it into State A, where the defect finally manifested?
Oh, wait. This circles back to my independent motorcycle dealer hypothetical. The consumer transported the product across the invisible boundary line, Ford didn't orchestrate the sale of that specific car in State A.
Exactly. And Ford argued exactly that. They told the Supreme Court, look, we did not cause this specific injury in this specific state because we did not sell this specific vehicle here. There is no unbroken chain of but-for causation linking our local advertising to this particular car.
And what did the Supreme Court say?
The Supreme Court rejected that defense and affirmed specific jurisdiction.
But why the different outcome? If the independent motorcycle dealer is protected when the consumer moves the bike, why is Ford on the hook when the consumer moves the car?
The distinction lies in the sheer scale of the market cultivation and the nature of relatedness.
Ah, scale.
Right. The motorcycle dealer was an isolated shop operating exclusively in one state. Ford actively, intentionally, and continuously cultivated a massive market for that exact type of vehicle in the forum state. They spent years urging the citizens of State A to buy, drive, and trust that specific model.
So they basically laid the groundwork.
Exactly. Because Ford deliberately saturated the forum with a market for the product, and the plaintiff suffered an in-forum injury involving that identical product, the lawsuit fundamentally relates to Ford's activities there. The court ruled that you do not need to trace the exact geographic path of the singular metal object, provided the company's broader forum activities share a strong affiliation with the litigation.
Ford essentially primed the environment for that vehicle to exist and be driven in State A. That makes a lot of sense. Now let's pivot to the Bristol-Myers case.
Okay, let's do it.
On the surface, it shares the exact same DNA. A massive corporation, a dangerous product, and a huge market presence. But the jurisdiction argument falls apart.
Right. So Bristol-Myers Squibb is a pharmaceutical giant selling a particular drug nationwide, which includes distributing millions of pills throughout California. A massive group of plaintiffs filed a lawsuit against the company in a California state court, alleging the drug caused severe health complications.
Okay, so the company availed itself of California by selling millions of pills there. The lawsuit is about those pills. So far, it tracks exactly with Ford.
For the specific plaintiffs who actually purchased and ingested the drug within California, jurisdiction was perfectly sound.
Okay.
The structural problem arose because this was a mass tort action. Hundreds of non-resident plaintiffs joined the California lawsuit. These were individuals who lived in Ohio, Texas, and elsewhere. They bought the drug in their home states, took the drug in their home states, and suffered their injuries in their home states, yet they wanted to consolidate their claims and sue in California alongside the local residents.
I mean, from a logistical standpoint, pooling resources in one massive lawsuit is incredibly efficient for the plaintiff's attorneys.
Oh, it is highly efficient, yes. But Bristol-Myers argued that California lacked the sovereign authority to adjudicate the claims of people who had no connection to the state.
And the plaintiffs?
The out-of-state plaintiffs countered by pointing to the company's massive California footprint. They argued, hey, Bristol-Myers sells millions of the exact same pills here. They purposefully availed themselves of this state. Our claims are for the identical drug. The lawsuits are related.
That sounds pretty convincing. How did the court resolve that tension? Because if Ford can be sued for a vehicle they didn't explicitly sell in the state, why can't Bristol-Myers be sued for a drug they heavily distribute in the state?
The Supreme Court ruled against the out-of-state plaintiffs. Specific jurisdiction failed for anyone who did not purchase or ingest the drug in California. Yeah. The underlying reason goes back to the concept of state sovereignty. In the Bristol-Myers scenario, the non-resident plaintiffs had absolutely zero personal connection to California, and their resulting injuries had zero connection to California. They were attempting to leverage the fact that the company sold the drug to other, completely unrelated people in the state.
Wow, so they were basically trying to borrow someone else's jurisdictional hook.
Exactly. The court established a rigid boundary. A defendant's contacts with other plaintiffs do not manufacture jurisdiction for this plaintiff. You cannot piggyback on the forum contacts of a stranger.
That's a great term, piggybacking.
Yeah, and if the Supreme Court had allowed that kind of piggybacking, California would effectively be transformed into the courthouse for the entire planet. Any massive corporation selling products nationally could be sued in California by anyone in the world for any reason.
Which could be chaos.
Complete chaos. And it completely strips states like Texas or Ohio of their sovereign right to manage the legal disputes of their own citizens.
Looking at both cases, the dividing line becomes so much clearer. In the Ford scenario, you have this incredibly rich soil of related forum activity, local advertising, the dealership network, combined with the seed of an in-forum injury. the plaintiff actually suffered the harm within State A.
Right.
That combination grows into a robust jurisdictional link. But in Bristol-Myers, the out-of-state plaintiffs are essentially trying to harvest crops from a completely different farm. You can't stand in a California courtroom and say, you injured a local resident here, so I demand you compensate me for what you did to me back in Texas.
The farm analogy illustrates the boundary perfectly. Ford requires related forum market activity, culminating in an in-forum injury. Bristol-Myers dictates that unrelated forum activity, even if it involves the exact same type of product, cannot sustain the claims of an out-of-forum plaintiff.
Okay, so we have successfully assembled the first two components of our specific jurisdiction engine.
Yeah.
We identified the defendant's deliberate, purposeful contacts. We confirmed that the lawsuit meaningfully relates to those specific contacts. The engine is fully operational.
It's humming.
Does the judge just bang the gavel and declare that the court has jurisdiction at this point?
Not immediately. Only after the first two steps are verified does the court step back and perform a constitutional gut check. This is part 3, the fairness analysis.
A gut check. But if the defendant deliberately targeted the state and the lawsuit is related, what could possibly make the lawsuit unfair?
Well, the framework comes from the legendary International Shoe case, which established that asserting jurisdiction must align with fair play and substantial justice.
Fair play and substantial justice. Got it.
Right. The court evaluates several factors: the logistical burden on the defendant to travel to the forum state's inherent interest in adjudicating the dispute, the plaintiff's interest in obtaining convenient relief, and the overall efficiency of the interstate judicial system.
Okay, I'm going to challenge the practical reality of this. Let's say I'm a small, independent craft maker living in Maine.
Okay.
I deliberately sell and ship a custom piece of furniture to a buyer in Hawaii. The furniture breaks, injures the buyer, and they file a lawsuit against me in a Hawaiian state court. Now, the expense of hiring local Hawaiian defense counsel, flying across the Pacific Ocean, and taking weeks away from my business that is a massive, potentially bankrupting inconvenience for me. Doesn't that extreme ordinary inconvenience tilt the scales of fairness in my favor?
It is a common defense strategy, absolutely, but the jurisprudence firmly shuts it down.
It does.
Yes. When purposeful contacts and relatedness are solidly established, meaning you deliberately chose to serve the Hawaiian market and the lawsuit is directly about that transaction, ordinary inconvenience will almost never defeat jurisdiction.
Wow. Even flying to Hawaii.
Even Hawaii. The defendant bears a monumental burden to prove that litigating in the forum would be so gravely difficult that it violates their constitutional rights. Sleeping in a hotel and paying for commercial airfare does not clear that high bar.
So under what circumstances does the fairness factor actually override the first two parts of the engine? When does a defendant actually win the fairness argument?
It is reserved for highly unusual, severe circumstances. Imagine a multi-generational mom-and-pop wood carving shop located in a rural village in Italy.
Okay.
They sell a single custom carved statue to a tourist from Texas, and they ship it to the buyer's home. The statue splinters, causing a severe injury. The Italian carver technically reached into Texas by shipping the product there, fulfilling parts 1 and 2.
Right.
But forcing a tiny foreign rural entity to navigate the American legal system, hire Texas litigators, and translate decades of documents across the Atlantic creates an insurmountable, crushing burden. In that specific context, the international complications and the severe financial destruction might allow fairness to override the context.
I see.
For domestic U.S. defendants, however, ordinary inconvenience will not save you.
That brings us to the ultimate trap hidden in our sources. The fairness analysis is a final check, but it is not a substitute for the foundation.
This is perhaps the most critical takeaway for anyone analyzing this system. Fairness cannot replace contacts.
But what if the practical realities heavily favor the plaintiff? What if a plaintiff is severely disabled from an injury, they're completely immobile, and it is overwhelmingly efficient and convenient for everyone involved to hold the trial in the plaintiff's home state?
It's a tough situation, obviously.
Right. Why should a technical lack of minimum contacts by the defendant force a sick plaintiff to travel across the country?
Because the entire system is anchored to the constitutional due process rights of the defendant. A judge cannot look at a docket and say, well, the defendant didn't really target our state, but the plaintiff is highly sympathetic, local litigation is highly efficient, so in the interest of fairness, we will assert jurisdiction. Doing so completely erases the concept of state sovereignty we discussed at the very beginning.
So the constitutional baseline demands that the defendant's actions must always be the anchor.
The contacts must come first. You cannot generate minimum contacts out of sheer convenience or sympathy. Furthermore, the mere foreseeability that a product might eventually cross state lines is not enough to manufacture those contacts either.
Which goes back to my customer moving the motorcycle in a U-Haul.
Mm.
I mean, it is entirely foreseeable that a wheeled vehicle will cross a geographic boundary.
It is highly foreseeable, but the legal test is not whether the defendant could foresee their product migrating. The test is whether the defendant could reasonably anticipate being hauled into a foreign courtroom based on their own forum-directed conduct.
Right.
You can foresee a product moving, but if you didn't direct your own energy at the destination state, the fairness analysis cannot artificially create jurisdiction for the court.
Pulling all of these threads together, what is the ultimate takeaway for you listening to this deep dive? Whether you are deep in the trenches of studying for the multi-state bar examination and trying to avoid the Bristol-Myers trap, or you are simply a professional trying to navigate liability in a modern, interconnected economy, mastering the mechanics of specific jurisdiction is essential.
It really is.
It pulls back the curtain on the hidden architecture of the judicial system. It proves that a court's power is not arbitrary or based on convenience. The invisible net is woven with highly specific requirements: deliberate actions, strictly related claims, and constitutional due process. You have to trace how those threads connect before you can understand who actually gets caught in the net.
It represents a delicate, evolving balance. The framework is engineered to protect state sovereignty and shield businesses from unpredictable ambush litigation, while simultaneously ensuring plaintiffs have a viable courtroom when a distant defendant genuinely targets their community and causes harm.
That evolving balance leaves us with a fascinating, unresolvable question for you to consider. Everything we have discussed today, shipping custom furniture, driving cars, selling pills, it all relies on physical objects crossing physical boundaries.
Right.
But we are operating in a world where commerce is increasingly virtual and entirely borderless. A single digital software download, a viral social media campaign, or a cloud-based AI service can simultaneously reach every single jurisdiction on the planet in a fraction of a millisecond.
Yeah, the internet changes everything.
It really does. How will the judicial system eventually define deliberately targeting a forum when the digital product exists everywhere at once? If a company's actions are instantly ubiquitous, does the strict geographic concept of specific jurisdiction even make sense anymore? Ponder that the next time you step across an invisible legal boundary.